we're getting already a lot of questions from TikTok. Uh, Three or four of them are the same question from different people, but they want to know, do you practice elder law and what is elder law?
I do practice elder law. So elder law is a specialty inside the world of estate planning in order to protect people's assets. What I keep hearing is there are benefits the government can offer to people for assisted living and skilled nursing. And people continue to think that you have to go broke in order to qualify for those programs. And that's not the case. There are ways to very, very respectfully and with high integrity protect the assets of people who work their whole life to have a retirement, to leave them comfortable, and then find they're confronted with somebody's physical disability or someone's mental incapacity through dementia or Alzheimer's. And the government has put in place ways that those assets can be protected. And those are Medicaid assets, and the rules for that vary from state to state. They're not exactly the same. There's generally an asset cap, meaning how much money can you have, and there's an income cap. I think that's national. So currently, a person can have $2,982 a month in income, and an individual could only have $2,000 in assets. But there's a way to protect what you've worked hard to get, and it involves people willing to be totally candid about their situations. I've heard of situations where one party, a spouse or a child, thinks their parent needs some kind of assisted living. And when somebody comes either to do an interview or to do a home visit, instead of telling them about their parent's worst day, they tell them about their parents' best day because they're so uncomfortable talking about their worst day. The worst day when they weren't sure how to pour a cup of coffee, or they weren't sure how to get into the shower. They talk about their best days, where the only thing they did was forget where their car keys were, let's say. So planning for it requires that the attorney have great compassion for a situation that nobody could ever envision. I believe for years that marriage vows people can get for richer or poorer, or sickness and health, but it's really hard to get for better or for worse because people can't envision the worst. That's my opinion, anyway. So you're in this worst situation, and it really demands you work with somebody who is empathetic at the same time as they're direct, so that you tell them what you need so they can get what you need and you can get taken care of. So that's elder law in a simple.
Debbie, I still remember when we first talked about you coming on the show about 2 years ago, maybe longer. But the first thing you said to me that really impressed me was, I want to keep my clients out of probate. Now, if you've never gone through probate is extremely expensive. And to hear an attorney say they want to keep you out of probate, that's how attorney makes their money. I was just so impressed with that. How do you do that?
When an estate plan is done correctly, probate happens when somebody passes and they have an asset that they owned only in their name. So they might have a will which says their car goes to their spouse. That could be taken care of. But they have a bank account that for some reason they never named the beneficiary for. They never named somebody to get that account when they pass. And I've had more than one case like that. And so when that happens, it's not that the will doesn't say Steve gets everything. The challenge is because I haven't put Steve on that account, the court has to be sure it's legitimate, and probate is needed so that account goes to Steve where it should have wound up easily. And I had a case this year where a man's wife died, and everything she had except for one account, she had him as beneficiary. And by not having him as beneficiary, do a probate, and because she had a child from a previous relationship, the husband was due half of the account, and the daughter was due half of the account. If the woman had only the husband as the beneficiary, he would have gotten all of it. So it's people forget. They have accounts that they've had forever, and then they get married and they forget. In this case, when the husband asked the bank what had them not have a beneficiary, whoever he spoke to said, well, we don't ask our customers unless they bring it up, which was like, oh my gosh. So, but that's what probate happens when you have an asset that you haven't given somebody legal right to have other than a will. Bank accounts don't pass by will. Houses don't pass by will. People think oftentimes that, well, I said that my spouse could have my house. Well, you didn't put your spouse on your deed or do something else, and so that has to go through probate. So the courts make money, and the attorneys make money, and it costs the estate money. That's why probate happens. That answer your question, I think.
Yes.
Yeah.
So, and I've got so many people writing in questions. Here's one. How do you get somebody, because I guarantee you, in your area of law, people procrastinate, probably more than any other area of law. Tell people why they shouldn't procrastinate.
Well, you've heard me say this, and for people who have, what I tell people is if you hate your family, don't plan. Just don't, because they will pay for it. They'll pay emotionally, they'll pay financially, and if they didn't like you before you died, they'll like you even less. People procrastinate because they think they don't have anything. Oh, I've met several people recently who say, I don't have anything. Do you have a bank account? Yes. I said, so you have something. Okay. So $500 in a bank account, even $100 in a bank account, you have something that you can beneficiary designate. Doesn't need a lawyer. They don't plan because they think it's too expensive, and they've never checked it out. So everybody listening or watching has purchased an item for the first time for which they had no frame of reference about what it would cost. And it seemed like it would cost a fortune. So I'm looking at Steve's backdrop, which says, ask the experts. But let's just say it was beautiful wallpaper, and you've never wallpapered anything before, and you go to do it, and you remember your mother telling you that she wallpapered your bedroom for $100, but that was 30 years ago. So for some reason, you think it's going to be $200, and they tell you it's going to be $1,000. Until you do some comparison shopping, you have no frame of reference, but that's why another reason people don't do it. People don't do it because they think they'll die as soon as they do. And I will tell you from personal experience, that happens. That's not a reason not to do it. That's not because the person it happened to had no signs that he was going to die. He just died. So, and then they die because they think their family will take care of it in a loving manner. And they don't understand the grief and angst and family divisions and splits and dissolutions that come as a result of not doing the planning. But those are the biggest reasons. So people call me often because they've just been through probate with a friend and they never want to do it for themselves. They call me because their parent is evidencing some kind of cognitive impairment, regardless of the age, and they've got to get it done for their parent, and they're going to do it for themselves as a preventive. But why people? So actually, I have round two. It's Steve's seen these, and a woman last week said she and her husband haven't done it because they haven't gotten around to it, and it was this lighthearted conversation. So I'm mailing her around to it, so she can get around to it. But those are the reasons. They don't think they have anything. They think it's too expensive. They'll let their family take care of it, or they think they'll die.
You know, I received an email from another state. A person said that they had talked to a relative who had an estate planning done, and they told them the price. So they didn't do it because of that reason. But everybody's case is different. You can't say one person, because they paid this amount of money, that it's going to be the same for you, right?
Yeah. I mean, people say that one of the first things I learned in law school, which made me laugh, was a totally legitimate thing to say to anybody when they call you is, it depends. It depends. I mean, Steve's situation is different than Steve if he had a wife. It's just different. Or if he had children, or if he had children, but he had a disabled child who was going to need government benefits, if not now, but later. So every situation is different. And one of the best things for me about working for myself is I'm more than willing to hear that somebody says, I don't have whatever that kind of money is, whatever that kind of money is.
Yes.
Well, my goal is not to do it for the money. So if I can get you settled and we can agree on a fee that I don't feel disrespected, you don't feel like you're taking advantage of me, and everybody's happy, then I'll get the work done, because it's more important that you have it than anything else. So, and there are people who spent a lot of money on a trust or something and found that they never funded the trust, whatever that means in the state they were in. So effectively, they've done nothing. And in that case, they probably overpaid. So you have to be careful that the attorney you're talking to knows what they're doing, so that doesn't happen.
So this is really a strange letter that I read. I don't know if you've ever heard this before. The person said, I am so paranoid. If I go and have my estate plan done, then I'm going to die the next day.
Yeah.
Have you heard that before?
Yeah. I had a client. No, I've heard it before, and haven't had those people act. What I have had is what I said a few minutes ago, is I had somebody sign all their documents and he died the next day. Died 10.5 hours after we signed the documents. And it made his wife's life so much easier, because she had the document. Oh yeah. No, I've had people say, I'm not going to do it because I'm going to die. Yeah, well, okay. Not a very reasonable, understandable fear. Not a good reason not to do it.
And here's something I'm sure that you just grinch when you hear it. People say, I'll just let my family take care of it after I die.
Yeah. Well, and as I said, people who say that sometimes say it in love, sometimes say it like, who cares? Thinking that it's easy. But so they've never been through. I've seen 2 or 3 families, actually, where planning was done, and they don't speak to each other anymore because of the arguments that ensued. So to not do it, people say, the beneficiary in my bank account is my oldest because they're the most responsible, and I know that they'll share with their siblings. I say, absolutely not. Well, why? Because you have no idea if when you die, that sibling that you gave all your money to is going to even be happy with the way their siblings treated you, and they were under no legal obligation to give you the money. None. They have no legal obligation to share that money. So that's the calculated reason. The emotional reason is, don't put it on me to give money to my 3 brothers when the bank can just as easily distribute it. Don't leave your family to take care of it. Do not. Are there exceptions that prove the rule? Absolutely. There are probably lots and lots of exceptions that prove the rule, that you can leave one person in charge and get it done. But I would say, don't take a chance. You won't be here to listen to them hate each other, but they could wind up really hating each other because you did or you didn't have the courage to just do something else.
Debbie, what is your message to people who say, well, I'm just going to do my own will?
Oh my gosh.
Do it.
Oh, yeah. Thank you for asking that question. No, well, generally, until last week, it was like, don't do it because you can't be sure it's state specific and you can't be sure it'll include everything you want. But just recently, a guy did a will for his father, and he got it signed by his dad, and he got it witnessed and he got it notarized, and it's not acceptable in the state of Florida because the notary block was incorrect. And so it's effectively useless. And I'm going to write a blog on that, because every other time it's do it yourself, it's like all those risks. You do one that says it's Florida specific, but it's really not. But this notary block not being correct, the notary should have caught it and could have made it correct. So the notary block will say, I watched Steve Sanger sign, and then I watched Debbie Baker and Joe Smith sign as witnesses and on a date, and he notarized it. But Florida demands that it says, were we physically present, or did the notary personally know us? And if not, did we produce identification? And this notary block was missing those qualifiers, and it's not valid. And this poor guy, his father got diagnosed with terminal cancer and like 4 weeks later passed. Thought he'd gotten it taken care of for his dad, and he didn't get it taken. And because I'm reading it and thinking, this is great. And I got to the notary block and I went, oh, this is awful. So do not do it yourself. There are good, valid, powerful. For people who are convinced they can't afford it, go online and look for Legal Shield or Prepaid Legal. I never remember what it's called. It's a monthly subscription. There's no contract. They are board certified, not certified, but they are people, licensed attorneys in their state of operation, and they can get you started with something simple and basic. But don't do it yourself. And with that notary block, I'm even more adamant. Don't do it yourself.
I'm going to get this.
Okay, we have 4 minutes or 1 minute? What is it's
I think it's I'm looking at these questions. I'm sorry. So when it comes to estate planning, people want to know if they live in New York half the year and the other half in Florida, are the laws different?
They are. Generally, what we recommend, you would do your estate plan in the state in which you have your domicile, like where your driver's license is. That would be your domicile. But generally speaking, I think, universally, if you have a will in a different state and you die in Florida, as long as that will was executed in compliance with the other state's rules, it'll be recognized in Florida. The thing we recommend for people who are snowbirds, 6 months and 6 months, we recommend they get healthcare directives in Florida and they get a power of attorney in Florida, because you don't want to bring one of those documents to a financial institution or a doctor and have them not recognize it because they're not used to what it looks like. So you wouldn't have to do a will over or anything else, but we recommend powers of attorney and healthcare directives be done in the state where you don't live most of the time, but the state where you spend a good part of your year.
How do people reach your office?
Okay, I'm available. My phone number is 813-586-1332, 813-586-1332. And the email is Deb Baker, 2 B's, at London, like the city, LondonBakerLaw.com. I return all my phone calls. You don't have to live in Florida. I'm happy to talk to anybody. I can't give advice specific to any other state, but I can give you counsel about questions to ask or who to look for, and possibly even find you a referral in a different state if need be.
Debbie, again, it's with us the last Monday of the month at 9:00 Eastern time. Very easy to remember. And we replay her show throughout the month. Debbie, thank you so much. Have a wonderful and blessed 4th of July.
Kiddo. See ya. So long.